Well, live.
The honorable judges of the Supreme Court and the Chief Justice of India to join us in the next couple of minutes, and we will start this session then. So please bear with us for a few minutes. Thank you. Gupta, and I'm the founder and research director of the Vidhi Center for Legal Policy. In 2017, the Chief Justice of the United States Supreme Court, John Roberts, was asked about the prospect of artificial intelligence helping in fact finding in courtrooms and perhaps even deciding cases. He said that that day has arrived and it is putting a tremendous strain on our judicial resources. In India, we are doing things a little bit differently. Once he took over as Chief Justice of India on the 26th of November 2019, in his Constitution Day speech, Chief Justice of India S.A.Bobde had said that artificial intelligence tools must supplement and not supplant judges, and they must be used to aid certain decisions and not make significant decisions. I am delighted that towards the close of his tenure as Chief Justice of India, Justice Bobde is here today to release our report titled Responsible Artificial Intelligence in the Indian Justice System. Thank you very much, Chief Justice, for gracing this occasion with your presence and presiding over it. I'm also delighted to welcome Justice L.N.Rao, Judge of the Supreme Court of India and the chairperson of the AI Committee. It's been under Justice Rao's stewardship of the AI Committee that the Supreme Court has developed Subhas, a translation tool which Justice Bobde had originally thought up, and Supace, a case query tool, both of which have transformative potential. Thank you very much, Justice Rao, for joining us today. I'm also delighted to have Justice B.N.Srikrishna, former judge of the Supreme Court of India. He may be a former judge, but he is one of the most forward-thinking members of the legal fraternity. And although he is a septuagenarian, at least for a few more months, his grasp of AI is better than most of us here today, and he has really shepherded this paper. So thank you very much, Justice Srikrishna, for joining us.
Thank you.
I'm also delighted to have Professor Partha Chakrabarti. Professor Chakrabarti is a former director of the IIT Kharagpur. He is a professor at the IIT Kharagpur and is one of the thought leaders of artificial intelligence in India today. He's also one of the co-authors of this paper, and delighted that as a technologist, he could come and be a part of this interdisciplinary exercise. Thank you, Professor Chakrabarti, for joining us. And last but not the least, we have Christoph, who is a professor at Harvard and ITAM, Mexico. He is the founder of the Legal Priorities Project, and in his own words, his research interests are the very long-term problems of law and the legal system, especially those posed by artificial intelligence. Thank you very much, Christoph, for joining us today. So without any further ado, I would now like the Chief Justice of India, Justice Bobde, to pick up the first copy of the report, which is in front of him, and ceremonially hold it up and release it. Thank you very much, Justice Bobde, for doing that. Now I hand over to my colleague and co-author of the report, Vaidehi Mishra, to give you a brief description of what the report contains. Vaidehi, over to you.
Thank you, Argo. Is this visible?
Yeah.
Great. So, our report can be broken into 4 different parts. The first, identifying potential and current use cases of AI. The second is a global survey of all the use cases. Third is the potential challenges that lie in integrating AI. And finally, we try to identify a roadmap that is specific to the Indian justice system. As you will see in this slide, across the globe, AI has been used with varying degrees of success. Primarily, they're used for 2 purposes. One, to increase administrative efficiency, and second, to supplement human decision making. Overall, there is a trend of having a generational adoption of AI, that is first in using AI to increase administrative efficiency and then using those lessons in order to supplement human decision making. Two of the examples of the countries here are provide use cases that can be adopted in the Indian context. First is Austria, which has a sophisticated document management system and also a digital assistant to digitize analog case files. And the second is Singapore, which uses real-time transcription of its court proceedings. These are both examples of simple AI solutions that can help expedite court processes that otherwise require a lot of judicial time. One of the key elements of our report is trying to identify a roadmap that can lay the foundation for a robust integration of AI for the various use cases that AI has to offer. There's a three-pronged roadmap that we identify. First is to conceptualize, which is to adopt a governing charter regarding its ethics, have stakeholder consultations in order to come up with the charter and a plan to conceptualize for AI, and also plan for capacity building. The second prong is to operationalize and provide a support system that can enable the integration of AI. This can be done by having openly accessible databases, which is a precondition, and also harnessing the innovation of the private sector. And finally is to deploy AI itself in a phase-wise manner. One of the manners in which it can be done phase-wise is through the generational deployment, which I was mentioning earlier, which is one of increasing administrative efficiency and then supplementing human decision making. In order to ensure that AI continues, the growth of AI is continuous and progressive, we can have feedback loops and have impact evaluation networks. Finally, one of our attempts is to provide a charter for responsible AI, which is essentially a governance framework that can help have an ethical framework for integrating AI. A couple of the principles that we have identified is a dynamic and iterative ecosystem, which is essentially enabling training and knowledge accumulation to comprehensively integrate AI into the justice system. The second is to amplify justice delivery. As Justice Bobde has mentioned, Chief Justice Bobde has mentioned that the idea is to supplement and not supplant human decision making, and to improve efficiency and eliminate backlog. And finally, which is the cornerstone of any ethical framework, is to secure the rights of individuals, which is to preserve constitutional, fundamental, and legal rights by having technology neutral principles, having the right to explanation, and having algorithmic transparency. I'll now hand it over to Amin to take this further. Thank you.
Thank you, Vaidehi. Just a small note. So the report is now formally available on the Vidhi website for all those who are interested in perusing it. I want to now take this forward to the main part of this conversation. Our first speaker today is Justice B.N.Srikrishna. As Orgo already mentioned, he is a former judge of the Supreme Court and has an extensive experience of working on some critical tech policy issues of our age. He is perhaps most recently renowned for steering the committee that drafted the Personal Data Protection Bill. Today, he will be discussing the necessity for openly accessible judicial data sets, which, as Vaidehi mentioned, are a prerequisite for any kind of current standard of AI innovation, and the need for adequate stakeholder engagement. Justice Srikrishna, the floor is metaphorically yours over this webinar.
Sir, you're on mute.
Introduced by your technical. All right. Chief Justice of India, Justice Bobde, Brother Judge, Justice Nageshwar Rao. In the 5 minutes that has been allotted to me, I can only shepherd 3 points of importance as I think them. One is, I had the privilege and pleasure of running through the report, even in its draft stage. And I must congratulate the E-Committee headed by Justice Rao, as well as all the experts who were there on the committee, including Professor Chakrabarti and my friend Arghya Sen Gupta, for the wonderful work that they have done. As the heading of the paper itself says, what we need is responsible AI. when we talk of responsible, it is necessary that all of us realize that artificial intelligence is just a means and not the end. The end of the legal system and the judicial system is to deliver justice. Therefore, we have to harness this potent instrument in order to achieve the objective with which we have all undertaken this task. The next point that I wish to make is that, yes, artificial intelligence is of tremendous importance to the judiciary in its ultimate task of justice delivery, because of various ways in which the system can be speeded up as indicated in the report itself. But one of the basic requisites, and in fact, the data is the raw material on which artificial intelligence works. Now, if you have to have data, you have to collect data from the various judicial institutions. Traditionally, our courts and judges are very conservative in the matter of sharing data. Therefore, there has to be not only a propagation of the fact that data needs to be shared, but also an inducement in whatever fashion that is possible to make sure that data is shared. Next point is, having collected a whole lot of data, there must be an absolutely adequate system of protection of the data from being breached. Now, since the law on that is still in the making, and I do not know what shape the law will take, appropriately, depending on what the shape the law takes, the action of the E-Committee will have to be tailored. And finally, and this is the most important point which came to my mind, that there should be a method by which the work that is being done, these various technical committees in the Supreme Court, should be made available to the public at large. I confess that although I have been a former judge of the Supreme Court of India, I did not know about anything about SUVAS and what is the other one, SUPAS or SUPESH, whatever acronym it has. Now, a simple suggestion that I have is, periodically a bulletin can be put up on the Supreme Court website saying that, hey, in the last so many days, this is the work that has been done. This is the work under process. This is what is going to be done. And if that is done, not only will the former judges and the lawyers, of course, they have access to that. The people at large will have an open access of saying that this is where it is available. This is the work that is being done. That is absolutely critical from my point of view. And finally, I would say that while we are all happy about the SUVAS and the other one is SUPESH or SUPASH, whatever Arkia pronounced, we'll have SUVESH, we will have SUNYAI, which is the most important thing for the court, and artificial intelligence will help us in giving SUNYAI both in the acronymical form and also in substance to the people at charge of this great country. Thank you very much. My best wishes go with all of you.
Thank you so much, Justice Srikrishna. Our next speaker is Professor Christoph Winter, who is an associate professor at ITAM, Mexico, and a visiting scholar at Harvard University. Christoph has worked and published numerous papers on how AI is currently being deployed in different jurisdictions and some of the long-term risks that this kind of an adoption can pose to justice systems at large. He will be highlighting some points on this cross-jurisdictional deployment and how the challenges in AI can be addressed for its safe and ethical deployment. Over to you, Christoph.
Thank you so much, Shami. And thanks to the organizers of this event and also to the co-authors of the report for inviting me. I'm very happy to be able to participate in this event. And I would, as Amin already alluded to, I would like to address two questions in my time. The first one being, why think about AI partially replacing human judicial decision-making, which could go beyond the tools introduced last week? And the second question, what to worry about and what to think about this and how to start the conversation with regards to AI replacing parts of judicial decision-making and not just adding to it. All right, so why think about it? I think the first reason is one of the most exciting reasons, and this is that it might offer an increase, a dramatic increase of access to justice, which from any somewhat reasonable moral, political, and even legal perspective with regards to fair trial would be a very welcome development. The second reason, coming from a bit more from a psychological perspective, being aware of the many flaws and cognitive biases and heuristics human reasoning uses, one might think, well, if we can just improve this sort of reasoning by using algorithms which can prevent such biases, if that is possible, then that could motivate us to achieve greater fairness by using AI instead of human reasoning, at least to some degree. And then the third reason why one might want to think about it is, well, even if we like it or not, it seems not unlikely that it will occur anyway, maybe not now, but maybe in a few years. And if that's the case, maybe we should start thinking about it already. And especially with regards to this last reason, we at the Legal Priorities Project were very uncertain about to what degree human judicial decision-making may be outsourced in the future and at what time. And while we had some very wild speculations ourselves, which also differed dramatically, we thought maybe it's a better idea to just ask hundreds of law professors and see what they think. And some of the most interesting results, and I should say I conducted this survey with my colleague Eric Martinez, and some of the most interesting results were that law professors on average, believe that within the next 25 years, roughly 30% of human judicial decision-making will be outsourced to artificial intelligence. And they also believe that AI will take over more than 50% of judicial decision-making at some point. So if we take these numbers somewhat seriously, and I think we should, we had over 500, to be exact, 512 law professors responding to the survey, including 43 who are based at a law school in India. If we take these numbers somewhat seriously, then this influences the second point I wanted to address, and that is what kind of questions we should start thinking about if there's just a chance that the average law professor might be right. And so some of this discussion has already started with regards to discrimination and transparency, and that seems to be very important. But if we take these numbers seriously, then I think there might also be issues arising which we are simply not aware of, some issues which have been vastly neglected by now, but which might be worth starting to think about already. So for instance, if we think that there is a chance that they're right, that roughly 30% of legal decision-making will be outsourced, judicial decision-making, I should say, will be outsourced, then this may change the people's perception of the judiciary. And based on this, it may change the position of the judiciary in the broader political system with regards to separation of powers, for instance. So if, for instance, the judiciary would be perceived as less democratic if a vast portion of it is conducted by artificial intelligence rather than by humans, then judicial independence may be under threat, maybe. How this would exactly play out seems to be very uncertain. And I'm not trying or not claiming to be able to make precise predictions. My main message is for today that we need to start this discourse of which problems may occur in different scenarios, even if we think they're somewhat unlikely, or even if we don't like these scenarios at all. And try to build related safety mechanisms based on these different scenarios. And I'm very glad that this report is starting this discourse to make sure that we build these safety mechanisms, but also by building these safety mechanisms that we're able to then reap all the benefits AI might offer with regards to access to justice and fair trial and so on. Thank you so much.
Thanks a lot, Christoph. That's actually quite helpful. We will now hear from Professor Chakrabarti, who is a professor at IIT Kharagpur. He brings a long history of experience in the field of computing and AI. Professor Chakrabarti will give insights into the different use cases that intelligent algorithms can be harnessed for to aid in procedural and analytical efficiency. Professor Chakrabarti, over to you.
Thank you, Amin. With respect to Honorable Chief Justice of India, Honorable Justice Rao, Justice Srikrishna, Professor Winter, Argho, Amin, Vaidehi, Thank you very much. It was a pleasure being part of this report with colleagues from everywhere else, including IIT Kharagpur, TCG Crest, ISER Kolkata, and obviously with the legal. I will share my perspective of how, what are the facets that are involved in developing responsible AI for the Indian justice system based on my understanding, experience, and thought. In the Indian justice system, AI can be used on 5 legs. The first is for analytical effectiveness. The second is for procedural efficiency. The third is for assistance in decision making. Fourth is for democratization. And fifth is for education. In analytical effectiveness, AI can be used, as Honorable Chief Justice just mentioned when SUPES was introduced, is in matching, similarity analysis, clustering or grouping of scenarios, segmenting facts, laws, rhetoric automatically, summarization, assimilation, anomaly detection, and various kinds of explanation generation in the whole process. These are very useful to any judge because of the enormous computing power that data churning can do by AI. The second is procedural efficiency. And in procedural efficiency, the problems that I have analyzed include allocation of resources, which involve people, courts, places, logistics, and everything else. Second is called scheduling. That means how and when, in what sequence am I going to do it? The third is called binding, which, in my opinion, after analyzing various courts from civil to high courts to Supreme Court of India, I have found that there are very intricate issues where the same case, follows different phases in a pipeline overlapped manner to improve the speed. And honorable judges have come out on their own to develop these organically, which typically you would see having done in an instruction set of an Intel computer. So this pipelining, execution, alerts, this will bring enormous procedural efficiency into the system. The third is decision assistance, where projections, scenario analysis, what if analysis. For example, if a judge says, if I take this decision, does it conflict with something else? Does it match with something else? So this whole concept of scenario analysis, recommendations in terms of providing various recommendations with whatever are the backgrounds of it and the explanations for it. Then is democratization. Everybody, Professor Winter talked about it. It is assistance to the public in complete and correct documentation, in legal question answering, and providing the public at large access to AI and justice in a democratic manner. Fourth is education, which is the least talked about. But here, with the whole of AI and the games that can occur, the whole concept of mock courts, mute courts, the whole concept of AI, robotics, etc., which we cannot use directly in the justice system, can be used in the education part by creating a lot of simulators. The question is that there are 3 ways in which AI is implemented. One is assisted. It assists the judge. The second is a little bit is embedded in assimilating all the information, but still it does not take decisions. The third is autonomy, where certain aspects of decision making are taken and then they may be vetted by the judge or in certain cases allowed autonomy. Now, in order to implement all this in a responsible and careful fashion, AI itself needs 4 legs. The first leg of AI in the justice system will be called the actor leg. The actor leg will implement all these 5 principles, 5 areas that I talked about. Then there will be the critic leg. The critic leg will be another AI system which will continuously critic whatever the actor is doing, so as to find and tell the actor that these are the issues which may be difficult. The third is the interpreter or the explainer link. And this will work on the actor and the critic and provide cogent explanations to the whole system. And the fourth is called the witness, monitor, and defender link. You will notice that as soon as you deploy AI, make everything public, there will be attacks and hacks on the system. Therefore, there needs to be a very strong AI-based defender system. So these are the four systems which have to be put in place to prevent against data bias, to ensure fairness, and to ensure that there is detailed testing and deployment. In order to do this, Justice Srikrishna has already talked about data research, but three things are important. One is pilots. We need to start pilots, and each of these pilots will tell us how the results of these pilots are, and inbuild some self-supervision in these pilots so that we can move in a step-by-step manner to get responsible ways of having responsible AI embedded. Having been part of this report, I feel that there is a long path to go ahead. Also, being a person who has developed the National Digital Library of India, we are very happy to be part of the Supreme Court process where we can democratize and provide information and knowledge on these aspects everywhere. Thank you again for making me a part of this. And I thank everybody else, IIT Kharagpur, the Supreme Court, Vidhi Legal, TCG, and everybody else who have been my colleagues to do this. I'll be very eager to continue this discussion. I am more of an action person, so I really want to see some action on the ground. And I will be happy to be part of this. Thank you again for making me part. Thank you.
Thank you, PPC. That's actually a lot of good and I think like very lucid technical insight into the things that need to go into actually realizing the kind of conversation that we're now having with respect to AI in the justice system. With that, I would now like to invite Honorable Justice Rao to share his thoughts on how AI is being envisioned for the Indian judiciary. Justice Rao, in addition to his ample judicial duties, is also steering the Supreme Court's AI committee, which only last week released a second pilot, SUPACE. Justice Rao, I request you to kindly deliver the address. You're on mute, sir.
Can you hear me now?
Yes.
Honorable Chief Justice of India, Honorable Justice Srikrishna, Honorable S.A.Bobde, Christopher Winter, Professor Partha Chakrabarti, Amin Johar, and Vaidehi Mishra. I'm glad to be a part of this launch of the strategy paper, Responsible Artificial Intelligence for the Indian Justice System. At the outset, I should congratulate Honorable S.A.Bobde for and his team for bringing out this paper, which will be very useful for persons who are interested in learning about artificial intelligence and its relevance to the judicial system in this country. Honorable S.A.Bobde has been in touch with me for the past 1 year. He was telling me about various other ideas of his on how to develop artificial intelligence tools which will be useful to judiciary. The suggestions that were made by Justice Srikrishna in respect of the tools that we are developing are well taken. I agree that there was not much publicity that was given to what we have been doing. There is a reason for this. We are still at a nascent stage, and the tools that we are developing are still a work in progress. We have taken the assistance of some experts who are still working on it, and we haven't really reached the efficiency of over 95%. We are almost there. We are still trying to reach that efficiency of over 95% to put these tools in place and use them. But still, what Justice Srikrishna suggested, that there might be some suggestions that might come from people who are experts in this field, which can be useful for development of these tools. So we will definitely start issuing bulletins with the assistance of the Honorable Chief Justice of India regularly, at least to inform the public as to where we stand with the tools that we are developing. The other point pertaining to data that was mentioned by the speakers, as of now, the situation is very fluid. As Justice Srikrishna mentioned, there is a lot of concern apart from the traditional mindset about the data being revealed, issues of privacy, especially in matters that are pending before courts. All these, I think, will take some time for us to take the suggestions that are made. I've gone through this strategy paper with
something like that.
So you're on mute again.
Somebody has muted everybody.
Yes. Yes. Am I audible now?
Yeah.
I have gone through this last chapter of the roadmap, which gives us several ideas as to how we can move forward with the applicability of the artificial intelligence to the judiciary. Apart from Dr. R.V. Gupta, we have also been in consultation with, I even asked Argyo to participate in a few meetings of the Artificial Intelligence Committee. We have also been in consultation with others who have interest in this subject and who are capable of giving inputs for development of artificial intelligence in the judiciary. Just to tell you what we have done till now. In the year 2019, the Supreme Court of India constituted the Artificial Intelligence Committee to explore the use of artificial intelligence in the judicial domain. The Chief Justice of India was the first chairman of the committee, and thereafter he appointed me as the chairman of the committee. I should say that during the past 1 year, for various reasons, blame it on pandemic or various other things, we could not make the progress which the Honorable Chief Justice of India desired. And I should also apologize to him for really not standing to his vision of where we should have been by the time he was laying down office. We are still somewhere at the threshold. The AA Committee of the Supreme Court identified 4 areas for implementation of artificial intelligence technology. One is the artificial intelligence language technology in translation of judicial documents. The second is the artificial intelligence in process automation on the administrative side. The third is the artificial intelligence in legal research assistance on the judicial side. The fourth is exploring potential use of artificial intelligence in other judicial avenues. Insofar as SUVAS is concerned, which is the technology being used in translation of judicial documents, in 2019, when the Honorable President of India visited the Supreme Court on the Constitution Day, he expressed his desire of making all the judgments that are delivered by the courts available in vernacular languages, which would improve legal literacy. He suggested that the common man should know about the judgments, and as all the judgments are in English, which are not translated into the local languages, most of them really don't understand what is there in the judgments and what is happening in courts. Taking cue from the suggestion made by the Honorable President of India, we thought of this SUVAS, which is a translation tool of judgments and documents from English to vernacular languages and vernacular languages to English. This apart, there have been a huge problem of translation of documents, especially judgments from some high courts, where the judgments are delivered in the vernacular language, especially in matters which were coming from jails, appeal being filed by convicts. The Legal Service Authority, though it was doing its best, it could not cope up with the demand of these documents being translated into English. And this was this was actually creating enormous delays in their appeals being filed and thereafter their appeals being decided. Added to the burgeoning docket of pendency of criminal matters, huge delays in this was taken up on the judicial side when I sat with the Honorable Chief Justice, when there were appeals being listed before courts with delays of thousands of days of delay, and the counsel saying this is a legal aid matter, so we have to condone the delay. We tried to find out what the reason was for this delay, and then we were told that translation was the main reason. And when I was in the Supreme Court Legal Service Committee, when I was a practicing lawyer, it took us 2 years to find the translators who could translate documents from Gujarati to English. In spite of our actually saying that we will pay you more and more money, but nobody was willing to come and then do this work. At present, we have lawyers who take up this translation of documents and helping the registry. So when we took up this SUVAS, which we thought that would really be useful to the common man, initially it took us some time to actually make a use of this tool. This version 1.5 of SUVAS has the following features to increase the translator's productivity and reduce cognitive load. They are intuitive and easy to use user interface, faster file translation for docx, PDF and TXT file format, intuitive and faster in-tool sentence correction, interactive translation to achieve translation as desired by the translator, file translation progress tracker, language-specific glossary definition, translated file document in text, document X experimental and XLX format, dictionary availability for every language pair, dashboard to capture tools, productivity and accuracy. From the side of the Artificial Intelligence Committee of the Supreme Court, I had a meeting with all the committees from the high courts and requested them to supply about 100 judgments of criminal appeals to the persons who are developing this tool. Most of them have sent those judgments. And as you all know, machine learning would be faster as more and more material is used. Machine learns by training. So we now find that we have almost reached about 91–92% efficiency. Still, there's a lot of work to do, as I said. Use of AI in legal research assistance and judicial side. The Supreme Court and benches of the high courts are required to hear and adjudicate complex cases with huge volumes of records. The need was felt for exploring the use of artificial intelligence in better understanding of the factual matrix of cases with intelligent research of precedents. AI also has a potential use in finding cases with similar identical questions of law so that the same can be clubbed and judicial time can be saved. This idea of developing this tool actually came from the Honorable Chief Justice of India about 2 years back when he was the chairman of the Artificial Intelligence Committee. He discussed this with a person with experience in this field, one Mr. Manthan Trivedi. And then it took shape, and as of now, last week we have released SUPACE. SUPACE, which is Supreme Court Portal for Assistance in Courts Efficiency, is one such AI tool the AI committee has developed. The salient features of AI portal SUPACE are file analytics, which automate and extract various facts from the file, identify and extract various objective facts like date, time, place of occurrence of event, etc. Locate various questions involved along with relevant answers. And the components used for extracting information are notebook. It allows the user to perform all the relevant tasks that are usually undertaken in a fragmented manner in any word processing software. Search text in file and chatbot. This chatbot allows the user to get automated recommendations or suggestions on any file, either through voice recognition or text-based search. It helps to extract various important facts from the file, which otherwise would occupy a considerable amount of time. The other tool that the committee is developing is an attempt to use artificial intelligence in process automation on the administrative side. National Judicial Data Grid is a part of the ongoing e-courts integrated mission mode project. It works as a monitoring tool to identify, manage, and reduce pendency of cases. Judicial Data Grid data reveals that Indian judiciary has pendency of more than 3 crores at different levels. Keeping a track of these cases in order to have special focus on cases which have been pending for a long number of years, cases pertaining to senior citizens, women, and public money is a huge challenge. AI committee is exploring the possibility of use of AI to achieve efficient case tracking and case flow management and to facilitate policy decisions. AI has potential to assist judiciary in increasing efficacy of justice delivery system while advancing our constitutional goals of justice, liberty, equality, and fraternity. I wish R.J. Sen-Gupta and his team all the best. Thank you.
Thank you so much, Justice Rao. I think there are a lot of good insights for each of us who's actually working in this space and getting some very candid information on how the judiciary is already working in deploying AI for procedural and analytical efficiency. With that, finally, it is my honor and privilege to introduce the Honorable Chief Justice of India, Justice Bobde. Justice Bobde has advocated the use of AI for improving institutional efficiency throughout his tenure at the helm. Honorable Sir, I request you to kindly deliver your address.
My esteemed colleague, Justice Nageshwar Rao, it is only so that I don't embarrass him that I won't call him my mentor, but Justice Srikrishna, from whom I've learnt a lot, Dr. Christoph Winter, Professor Partha Chakrabarti, Olga Sen-Gupta, Amin Johar, Vaidehi Mishra, ladies and gentlemen. I am delighted to be here, particularly in the presence of Justice Srikrishna. It is very difficult to see him or meet him these days, but at last Olga Sen-Gupta has got us together. Thank you, sir. I believe he is one of the finest combinations of ancient knowledge and modern expertise I know. It is fitting that he is here with us today. And I'm not surprised that Olga Sen-Gupta told me that he is a dynamic force driving the artificial intelligence movement in the judiciary in India. Thank you, sir, for being here. I must say that this has been a learning experience. From Justice Rao, I realized the scope and the width of the artificial intelligence program, which has been undertaken by the Supreme Court. Undoubtedly, COVID slowed everything, but it is very satisfactory that we have reached this far. And there is an old saying in Sanskrit, which if I commit a mistake in pronouncing Justice Srikrishna will overlook it. It says, Shanay Pantha, Shanay Kantha, Shanay Parvata Langanam, Shanay Vidya, Shanay Vittam, Panchayatani, Shanay Shanay. Meaning that these 5 things should be done very slowly. Undertake a long journey, handle a long plot, climb a mountain, acquire knowledge, and collect money, collect a fund. So it is just as well that we are taking time. I'm sure what will come out is something very good. I was also extremely impressed by what Professor Chakrabarti and Christoph Winter explained in their speeches. I see what the composition is, but we would like to have more of Professor Chakrabarti's inputs on our committees. For the Indian judiciary, this decade will mark a crucial phase as we work towards more technological integration and actively pursue the potential of AI for our justice system. In fact, I was extremely delighted last week to launch the Supreme Court's portal for assistance in courts efficiency, SUPACE, which marked the second watershed moment in the Indian judiciary's ongoing experimentation with AI. Previously, in November 19, I also had the pleasure of launching an indigenously engineered neural translation tool, SUVAS, which translates judgments and other legal documents from English into 9 vernacular dialects and vice versa. Both these tools and our ever-increasing reliance on emerging technologies like AI have been accentuated in the year of a global pandemic. It has compelled us to modernize our institution and ensure that access to justice remains uninhibited, even in the face of such catastrophes. The Supreme Court's AI committee has been working on designing and deploying intelligent and sophisticated technology for the past 2 years. The idea of a futuristic judiciary is no longer imaginary. Active steps are being pursued to realize it. However, while we focus on this endeavor, the use of AI, like any other transformative tech innovation, has its huge advantages and inherent risks. I must here point out that there is an approach avoidance conflict in our relationship with the AI. It is every time you see a particular feature and want to go ahead, you find something else which retards it and you want to avoid it. To borrow a phrase that has become quite common in AI ethics, we must strive to minimize the risks and maximize the advantages of AI. For this, it is crucial to establish a governance and ethics framework which allows for a responsible design and deployment of AI in our justice system. Additionally, it is vital to push for stakeholder engagement and ensure that technologies that are being integrated further the ends of justice for every citizen of India as mandated by the Constitution. And here, I must express what I have always felt about AI and justice. I believe, and I've discussed this with my colleague Justice Rao and other judges, I believe that justice as a response to events that take place in society is a response which involves the whole of the human being. It is not merely a matter of cognition. It is not merely a matter of being able to process thoughts and information about the incidents that have happened and come up for judging. That is the cognitive part of the human mind. And I believe, and I think all the judges will bear me out, that there are emotions and responses which are much wider and go beyond cognition. In fact, cognition begins much later. There is sometimes the element of shock at what has happened, a gruesome murder or a terrible event that has taken place in society. There are then, after the shock, the arguments, the reasoning, which leads to the ultimate decision making. I believe that AI follows the initial basic responses of the human mind to the situation. And to that extent, there is a natural limitation on AI. Undoubtedly, AI can do a wonderful job once it is given all the information, and it can also lead you to many places. But as Justice Srikrishna said, that it is the first point. The goal is not AI, the goal is justice. And therefore, I have persistently opposed what is known as automated decision making. It is not possible for a system of justice to accept that a machine, however intelligent, will take the decision. We have therefore, and I have also consciously, along with Justice Rao, taken this route that these assistive tools must give us all the information necessary to arrive at a correct decision of the case, a just decision of the case, as dictated by the demands of justice, the demands of law, the demands of the Constitution, and we will not allow it to tell us what to decide. We will also not allow it to tell us how to decide or when to decide. We will only use it to provide all the information which we need to decide the case at a high speed. I believe that the speed is about 1 million characters per second. There are many things which a judge knows, which probably AI experts may not be fully conscious of. There are some cases which involve thousands and thousands of pages of the written word, of documents, of various things which are written, the same thing. Sometimes it becomes necessary to see the same notice where the same thing has been said by various witnesses in different parts of their testimony. For example, to give an example, whether the blood group of the witness, blood group of the victim matches the blood group of the accused. Now, this is something which often determines the guilt in a murder case of a particular kind. And these things are these things are deposed to by various witnesses, medical witnesses, CFL, that is chemical forensic laboratory witnesses, all kinds of witnesses, and also how the weapon that was recovered from the scene, through what hands it went, and how eventually somebody spotted the blood group, these drops of blood, and sent it for analysis, and what is the result of the analysis. I don't want to spend a lot of time on this, but what I'm trying to say is, you can imagine if there is a case which involves hundreds of accused, tens of victims, you can imagine how much information on this small point arises in a case. Now, we are looking to find out how we can get this information most efficiently. I think Professor Chakrabarti used a phrase which I've forgotten, but how to extract this information. And this is where I believe the AI in the judiciary must end as far as decision making is concerned. There is, of course, another area, and I believe there is already an AI for that, finding out the latest position in law, the applicable precedent to the particular case. This is very important for us as judges to know efficiently. But beyond that, I believe in all humility that we must not allow AI to determine the outcome of a case. It is important that our future engagement with AI is governed by ethical, legal, and constitutional principles. Our AI committee may evolve the ethical principles after due deliberations and after sufficient of experience of the working of our system. I would like to mention that suggestions are welcome from all quarters, and I think they will speed up once we implement Justice Srikrishna's suggestion about putting it on our website. The Indian judiciary's usage of AI must align with our constitutional morality. It is vital that AI in no way impedes or undermines constitutional and legal rights afforded to Indians. Where we rely on any technology to aid the judicial decision-making process, it must be subject, as I said, to the final consideration of a human. And I don't know whether I'm using the right terminology or not, but I believe that AI works in areas of cognition which can be represented by words, which can be represented by symbols like alphabets and numbers. As I said, there is a lot of emotional basis to a decision which AI, I believe, cannot reach. For this reason, I have time and again opposed any algorithmic decision-making tools within our courts. Outside in countries like the US and the UK, such technologies have created a great furor over the questions of due process and fairness in adjudication. For example, in the United States, I believe an algorithm has been strongly criticized for its alleged design flaws and biases against minorities. Instead, the AI's use in Indian courts must focus on amplifying justice delivery through an improved efficiency of courts and aiding the decision-making process for judges, lawyers, and litigants. My esteemed colleague, Justice Rao, has ably gone over all the use, so I will not repeat it. But for instance, Victor is a court assistance AI tool which is being used in Brazilian courts. It is said to have significantly reduced the time judges take in perusing case precedents and applying them to a potential lawsuit. We should also focus on similar augmentative intelligent technology. One of the learnings from the e-courts project as well as of the pandemic-ridden justice delivery has been to ensure that no lawyer or litigant is left outside the purview of this technological transformation. The objective behind AI is to expand ease of access to justice, and it will necessarily require the buy-in of these two critical stakeholders apart from judges. I must here advert to something which I've necessarily had to advert to after the introductions of video conferencing in courts. We found that because video conferencing is a technology and therefore video conferencing becomes entirely technology dependent, its use depends on the possession of the devices which are necessary for video conferencing. We found that in India, it created I don't know whether created or maybe augmented an inequality which already existed. Access to courts via video conferencing depended on the person's access to video conferencing methods. The Supreme Court, I must say, came up along with the other high courts of an idea which solved it to a great extent by producing mobile kiosks which you could enter and simply access the court. I do hope that AI does not augment any existing inequality or create any new kind. The objective, as I said, is to expand and ease access to justice. Over time, perhaps after a few rounds of piloting AI-driven technology in Indian courts, it must also be integrated into the other pillars of the justice system, like legal aid and police. All these establishes a long list of to-do items from a technological standpoint for the Indian judiciary, especially the AI committee, which will be steering this process. As I mentioned, this decade will prove to be more transformative and pivotal for the Indian judiciary. The pilots that have already been deployed, namely SUVAS and SUPES, demonstrate the first generation of AI technologies for the Indian justice system. These must be improved and built upon to deploy even more accurate and sophisticated technological inventions. I would end with the great hope I have, which came from a story in the life of Benjamin Franklin after he demonstrated the first electric bulb. It lit for a few seconds and stopped. No, Benjamin Franklin. Anyway, it doesn't matter. There is some controversy here. I think it is Benjamin Franklin. He wanted to demonstrate how electricity can go through a filament and light up the area. And one smart Alec, and there are always those hanging around, came and asked him, hey, what use is this silly thing which lit up for a few seconds and went out? Franklin, I think, was so indignant that he turned around and said, if I may ask you, sir, of what use is a newborn baby? The AI may be at the most nascent stage. It may be like a newborn baby, but I'm sure it will grow to great strengths and achieve many things. Thank you very much. Jai Hind. Franklin, no?
Thank you so much, Honorable Chief Justice. With that, I do apologize. We are considerably over time, and therefore we don't have the capacity to take any questions right now. But I want to extend a warm sense of gratitude to all the speakers and the panelists who came for this event. And of course, the audience, which has taken this late hour in the evening to actually join us for this very interesting conversation. We are hopeful that our strategy paper is a first in the series of conversations that sort of erupt in the space, because clearly, as we have seen, AI in the justice system is no longer theoretical or fictional. It is very much a reality, and it is becoming entrenched in our legal system. So in order to develop it in a holistic and responsible way, more such points of view are very welcome and necessary. With that, I would like to close this event.
Thank you. I mean, just before you finish, I'd just like to propose a formal vote of thanks. First of all, thank you very much to the Chief Justice of India. He has really been the torchbearer of artificial intelligence in the Indian justice system. And I think the light that he has lit, whether it was originally lit by Franklin or Edison, is one that will continue in the justice system in India. I also would like to thank Justice Nageshwar Rao, as in he has provided great detail of what has happened with AI in the justice system. He may have, in his characteristic modesty, said that it was slow. I'd like to believe that the development has been steady. So thank you very much, Justice Rao, for shepherding this process of development of AI, as Chief Justice said, during its first generation. I'd like to thank Professor Chakrabarti for a beautiful conceptual framework in which he put the development of AI in the justice system. I think it really calls for greater interdisciplinary collaboration between members of the legal fraternity and those in technological fields. So thank you very much for your insights. To Christoph for looking at the long, hard questions, that AI is not just a bed of roses, but there are difficult questions to confront and how we confront them. And to Justice Srikrishna for really highlighting the need for responsible use of data and the need to open data sets in the Indian judiciary. Finally, I would also like to thank TCG Crest, Dr. Purnendu Chatterjee and Joydeep Bhattacharya, who brought the team from IIT Kharagpur, IISER and Vidhi together in order to do this paper in this interdisciplinary form. Thank you very much for getting us together. I'd like to end with what the Chief Justice said, is that AI must be used to supplement and not supplant judges. And this is captured in the report, as everyone can see on the website now, in a charter which captures these principles that artificial intelligence in the justice system in India must follow. And I hope that these will become part of the guiding documents for the AI Committee of the Supreme Court and the High Courts, so that they can outlive us all once AI becomes an entrenched feature of the judiciary in India. Thank you once again to everyone for joining us today, and a very good night.